everybody. Good morning. We are back here again today for the second Good Morning Live of the day. Week? I don't know. In a row? I don't know. So a lot of y'all were asking me to go over this yesterday and the day before. Excuse me. So I'm just going to go over it now today. Britney is free. Thank you, Oscar. Britney is free. But there's going to be a lot of stuff that we have to go over as a movement to make sure that everything's going to go wind down in the best way possible. To me, there were two main issues with Britney's conservatorship. She did not qualify for either one, but the main issues were they were trying to control her body and her choices, and they were trying to control her money, right? And so we are looking like we're getting to the end of them trying to control her body, right? Like where she can go, like basically trafficking her. But I don't think we're out of the woods yet with Britney Spears' money. And I don't think we're out of the woods yet with all of the people who are going to try and keep their little percentages that they have negotiated over the last 13 years. So what we are going to be looking at now is how the conservatorship team plans to wind down the conservatorship and what they actually plan to do in order to make sure that Britney is set up for success. Because Britney, she just told us yesterday on her Instagram, or maybe it was 2 days ago, it's so hard to keep track at this point, that she's never even seen cash money in real life. Like, maybe she has, but like the way that she said it, like she's never seen cash. So I think it's going to take her a while to get used to living life on her own, but I just want to be clear, I completely 100% support her going out there and living her life on her own. All of us, however old we were when we finally did move out of our parents' house, it was hard for us to figure out how to live our life on our own. Even if you were 16 years old at the time, all the way up to 30 years old, Britney Spears is just getting started a little later than us, but she deserves the right to take this autonomy and to make these decisions. It's just not very fair that she hasn't been able to be set up for success yet. So I've not read this document yet. I'm just going to go read it live with y'all like I normally do. But I do see that there are a lot of people who are a little suspicious of this document, and I can definitely understand why. So I just want to get into it, read it for myself, and then, make my own opinion, and then, invite y'all to make your own opinion as well. So let's see. So we have the document here. Sorry, I just got to get my little comment set up over here. I really probably should have like a second screen, but what are you going to do? Okay. So as you can see at the top of the screen, this document was filed on November 9th, 2021. That would have been 3 days before Britney's hearing. So it would have been filed like about a week ago on Wednesday of last week. The title of the document is Notice of Motion and Motion to Seal and Limit Service of Termination Plan. I don't know what that really means other than the motion to seal means they're trying to keep stuff hidden. Now, first things first, let's look at who filed this. Lori Ann Wright, who I'm very suspicious of. She is the lawyer for Jodi Montgomery, who is the temporary, excuse me. I need a water break, sorry. Temporary conservator of the estate. So she was the temporary conservator of Britney's estate, but now she is, I guess, like kind of going to be like some sort of appointed caretaker. So I'm fidgety this morning. Okay. So it is concerning to me that this is a motion to seal because of who is filing it. If you remember on June 23rd, when Britney actually spoke, Britney said, Jodi is actually getting a little bit too far. She's going a little too far. And if you remember, Lori Ann Wright is Jodi's attorney. She was the one who said, no, Your Honor, let's keep the courtroom sealed. Let's keep everything private and secret. And Britney said, Your Honor, I think they've done a pretty good enough job exploiting my life. So I would like the public to know what's going on in this hearing. I would like it to be an open hearing to the public. Okay, so now we have this same Lori Ann Wright coming in and filing another motion to keep these documents hidden from us. Now, Maybe I'm jumping the gun. Maybe it's good reason to keep these documents. Maybe there is truly private health information or something like that. But this is how I do it, line by line, right? I'm suspicious that Lorianne Wright is trying to keep things hush hush family secret. I am suspicious of Lorianne and I am suspicious of Jodi. They were totally Team Con, and I'm a little bit concerned that they're still going to be involved in this moving forward. I'm just telling you my opinion. Y'all can form your own opinion. Okay. And I'm reserved the right to change my mind as well. Okay. So memorandum on points of authorities, that's just like a memo where they're going to give you like case law and statutes to prove their point or to try and prove their point. And then you have a declaration of Lorianne Wright, who I'm very suspicious of, right? She's a conservatorship lawyer. We have to be suspicious of these people because without conservatorships, they would not make money, okay? Matt Rosengart is not that type of person. Without conservatorships, Matthew Rosengart would still make money. In fact, I doubt he's ever made money off of anybody's conservatorship until this case. So I'm slightly less suspicious of him than Lorianne Wright. And this is just my opinion. Thank you, Jadeite Lady. Okay. To all interested parties, again, this is my first time reading this, so I have an open mind. I'm going into it with an open mind, but I am a little suspicious. You are notified that on December 8th, 2021 at 1:30 p.m. in Department 4 of this court, blah, blah, blah. That's where we just were for the last hearing, that tiny little courtroom that only has 70 seats, even though there's auditorium-sized courtrooms in this courthouse. And they give 60 of the 70 seats to the media and actually up to 65 or 70 of the seats to the media. But if you want to know more about that, watch my live from yesterday. Okay. Temporary conservator of the person, Britney Jean Spears, by and through her attorneys, that's Jodi, moved for the court to order and seal and limit service of the termination plan. I think limiting service means that they're not going to actually give it to everyone who's on file in the case. Thank you, Allison. Specifically, Ms. Montgomery seeks an order to seal the entire termination plan, which I do not like this. Montgomery, no, I do not like this at all. And I'm very interested to see what Matt Rosengart files in response, if anything, which will be lodged conditionally under seal concurrently with the filing of this motion to seal. So this termination plan was already filed with the court. We're just not going to necessarily see it. And to limit service of the termination plan to only Britney's lawyer. So they're like, we don't want all this going to all the Geralds and the Geraldines and the Vivians and the Jonathan Parks and the Bruce S. Rosses and the Sam Inghams and Lynn Spears and Britney and all these other people's sisters and brothers. And all. We don't want to go on all these people. Literally, we just want it going to Matt Rosengart. The termination plan, again, they want it sealed from us. They don't want us to see it. Must be sealed in its entirety, because it contains information and recommendations based on Britney's private and highly sensitive medical information. And she just told us yesterday on her Instagram, she doesn't even have any real disabilities. So she's not even actually qualifying herself as disabled. Like, she's not self-identifying as a disabled person. And so it brings the question to my mind, what is this sensitive, highly sensitive medical information? What is so sensitive about it? Britney just said she don't have nothing wrong with her. Literally yesterday, she just said, I do not have any real disabilities. She said, I'm here to help people with real disabilities because they did this to me. I cannot imagine. Now, listen, I'm not here to define whether or not Britney Spears is disabled. I am listening and taking her cue on it. And she just said yesterday, I'm here to help people with real disabilities, which would be me, because I do self-identify as disabled. So I'm just really confused as to why this whole termination plan has to be sealed, because they have all this highly sensitive medical information and all this private information, whenever Britney already said, I want this stuff open to the public. So again, anytime I see things trying to be sealed entirely, I am suspicious. That doesn't mean necessarily that I don't think there is private information in there. It could be. But I am suspicious of an entire document being sealed because maybe there's some highly sensitive information in it. That is not how sealing orders are supposed to work. We are supposed to be able to see what is going on in our institutions to make sure that people like Judge Brenda Penny are not being corrupt. People like Lorianne Wright are not being corrupt. People like Jodi Montgomery are not being corrupt. And in fact, it seems as though they have been being corrupt. And so it's very concerning to me to see that Lorianne Wright, again, is trying to seal everything from the public view. When the last time she tried to do that, Britney literally interrupted her and said, cut her off, and said, I think y'all have done a good enough job exploiting my life. I want it public. So I'm just very concerned. I mean, I know we're only on page 1, but I am very concerned. How many pages is this document? I didn't even look. Yeah, we're going to be here for a while. Hope y'all have a long commute this morning. Okay. And then they always bring up the minor children, which like I never ever really talk about on my channel. Don't want to talk about them on my channel. Please don't comment about them on my channel. I do not want them brought up on my channel, but I am concerned and confused as to why they couldn't just black out the parts about them, the redact, take a Sharpie and black out the parts about the minor children. I don't understand why they couldn't just do that. There can be no public right of access to Britney's private medical information, which is true. That is true. There is no public right of access to Britney's private medical information, but this is a termination plan. It's not a medical file, right? Redact the medical information and let the public have access to what we have the right to have access to. Moreover, the personal private information relating to Britney's children is also per se confidential. Sure, black that part out. The whole thing is not going to be children and medical. I promise you that. So let us see those parts. The motion is based. Yeah, no, I agree. Danielle says the highly sensitive medical information. Yeah, since they made it up that Britney had all kind of health issues. They literally lied and said she had dementia. So Britney doesn't have dementia. That is not private health information that Britney has dementia, because she does not. And if I'm lying, take me to court. They clearly made them up and doped her up with lithium. They are trying to hide details. Agreed. Agreed, Danielle. Agreed completely. It's crazy the whole document is sealed. Completely agree. Seal the medical and kids and show the rest. Okay, let me get back to the screen for y'all. Okay, this motion is based on the notice of motion and motion, the attached memorandum, blah, blah, blah. Okay, so Lorianne trying to hide everything, hide the ball, right? Okay, so now they're going to get into the case law. This is what they're going to hang their hat on in a legal way of like saying, here's the precedent, here's the case law. Introduction. As this court is well aware, the petition for termination of the conservatorship of the person and estate originally was filed by her dad, is set forth for hearing on November 12th. So remember, this was filed 3 days before Britney's termination hearing, but it did not appear on the docket for any of us to see, which I think is a total setup. They did not want us to be able to see this. And if you go back and watch my video from yesterday, I really strongly encourage you to. I really outline how hard Judge Brenda Penny and the LA Probate Court at Stanley Moss Courthouse has tried to seal all of this information from the public and keep it from us as till the last second as possible. There's no reason it took 3 days to get this thing available to the public, 4 or 5 days even. The petition is not only unopposed, right? Petition to terminate. It is endorsed by all parties, and it is no longer a question of whether this conservatorship will end, but simply when, okay? In anticipation of its imminent termination. So like as Jodi and them are anticipating it's about to end any moment, Jodi, who was at that time the temporary conservator of the person of Britney, worked with her medical team. So Jodi worked with Britney's medical team. Whose medical team? She just says her, right? So what's really interesting is worked with her medical team. Well, it's funny because Jodi, according to documents, has actually been in charge of hiring the medical team. So it's kind of weird that it's her medical team. Yeah, like it's Jodi's medical team. To prepare, Britney did not choose these people. They would give her like an option of 1 or 2 people and they'd be like, oh, does this work for you? And she'd have to be like, yeah. Like she really didn't get into like chance like go through a phone book, go through the internet, go through ask a friend for a recommendation. She was given by Jodi and Sam Ingham, according to documents, like 2 psychiatrists to choose from, and she had to choose one of those 2. Now, the question comes up, who gave Jodi and Sam Ingham those psychiatrists? And were they getting some kind of kickbacks for choosing those particular ones? Like, that's really a question that we have to ask in this very corrupt conservatorship. Who was getting money for making these recommendations? Who was paying money to be one of those 2 doctors that gets recommended to Britney Jean Spears to know all of her most personal private information that she ever had to tell anyone in her life? You know what I mean? Like, think about that. Like, you're about to have to go to a therapist, court-ordered therapy, and you only get 2 choices, and it's who your abusers and your captors have chosen for you. Like, think about whether you would be able to actually trust that medical professional. It's no wonder Britney said in her testimony, I don't even want to go to therapy. I believe in praying and bringing it to God. No, I would too, girl. All these crooks and criminals around you. Temporary conservator, blah, blah, blah. All right. Since Britney has been under the conservatorship since 2008, Ms. Montgomery would like to ensure that there are guidelines in place for supportive decision making to help Britney adjust and transition to life outside of the conservatorship. The termination plan, therefore, necessarily contains sensitive and private information about Britney. Okay, that has nothing to do. This is a total non sequitur. Okay. So this is an important part here. Jodi would like to ensure that there are guidelines in place for supportive decision making to help her adjust and transition to life outside of the conservatorship. So something that I find interesting is that they're moving to supported decision making now. Supported decision making is kind of like a mutated strain of a conservatorship, to be quite honest. The thing is that ultimately the legal authority to make the decision will now lie with Britney. But supported decision making kind of puts a bunch of people in place to have to like check off Britney's decisions or put something in place where Britney will have to actually confer and consult with people before she makes certain big decisions. And we don't really know what that's going to look like, because what Jodi is asking for is just the guidelines. So if the guidelines are actually given to us here, then we would know what those guidelines are. But I am a little bit concerned that Jodi Montgomery, who Britney has told us was starting to get just as bad as her dad as recently as 3 or 4 months ago, is going to be the person in charge of supportive decision making. I am very suspicious, and I see why y'all are as well. The termination plan therefore necessarily contains sensitive and private information about Miss Spears' medical doctors, conditions, treatment, as well as information related to her minor children. And again, that is all fine and dandy, Lorianne. Just redact those parts and leave the other parts. You do not have to seal something in its entirety, because there are parts of it that need to be redacted, and you should know that. If you don't know that, perhaps you should go back to law school, take first year law school over again, because that is something that you learn at the very beginning. You do not redact, or you do not seal an entire document because there are redactable portions. That is unconstitutional, in fact. And again, we have to start asserting our constitutional rights. The public has constitutional rights to know how the courts are treating vulnerable people. Britney Spears in this particular situation is vulnerable. We have no idea what's in this termination plan. We don't know if it's Jodi paying herself $10 million. We don't know if it's Michael Caine paying himself $10 million. We don't know if it's Matthew Rosengart paying himself $10 million. We don't know if Brenda Penny's paying herself $10 million in this country. We have no idea, because there's some medical information in there. Black it out and let us see what y'all are doing. It's getting a little ridiculous, Lorianne, and you know it. And you know it. These are the exact categories of information that have been previously and rightfully sealed by this court in the conservatorship proceeding. Yeah, well, we hope, Lorianne. But all kind of stuff that wasn't supposed to be sealed has been sealed as well. And so let's not get carried away with what the court has done in the past, because the court in the past has conducted a trafficking scheme. So let's not be all, oh, the court did it in the past. Yeah, well, they also trafficked someone. So, and many more than one person. I've heard stories from many, many victims of the Stanley Moss Courthouse and Judge Brenda Penny and Sam Ingham. Many victims have had their rights and liberties taken away by this court. So just because the court did something in the past doesn't necessarily mean that they need to necessarily keep continuing doing in the future, because maybe in fact it's against the law and it's criminal. Maybe. There's no question that this information is not just per se confidential. Okay, again, this is all just like a stupid red herring. Oh, look, there's some confidential information in there, so we got to seal the whole thing. False. That's not how it works. That's not how it works. Well, I guess it is how it works in the Stanley Moss Courthouse under Judge Brenda Penny trafficking schemes, but I mean, in its prior sealing orders, this court recognized the overriding privacy interest in this case. Again, now she's about to rely on the past things that this court has done. Let's go over real quick some of the stuff this court has also done in the past. Violated Britney's right to an attorney, violated Britney's right to a jury trial, violated Britney's First Amendment free speech rights, violated Britney's freedom of the press rights, violated Britney's Second Amendment rights to own a gun, violated Britney's Fourth Amendment rights to be free from unreasonable search and seizure, violated Britney's Fifth Amendment right to due process under the law, violated Britney's Eighth Amendment right to be free from cruel and unusual punishment. I mean, I could keep going. Like, they've violated lots of like equal protection under the law. Like, I could literally find a way that they violated almost every single, literally even enslavement. They've literally violated the 13th Amendment and forced a woman into involuntary servitude. Literally. So just because this court did something in the past, honey, sweetie, baby, boo-boo, does not mean that they need to keep doing it. Okay? It's high time that lawyers start using a little bit of mother common sense. All right. I'm sick and tired of looking at y'all. You are embarrassing, Lorianne. You are embarrassing to this profession. This is embarrassing. Well, the court did it in the past. You know what else the court did in the past? Enslaved this woman. So let's not sit here and get all carried away with what the court did in the past as if it's some kind of beacon of justice and truth, because it's not. Thank you, Kale. Steve, I don't know. You'll have to go into that question a little bit more. She was a slave. She definitely was. And that's the thing. Like, she literally was enslaved. She literally was forced under the authority of the state, with the permission and power and force of the state of California, to work against her will, to perform against her will, to show up places and say things that she didn't want to say, do things she didn't want to do in order to make money for her handlers. That is trafficking. That is slavery. So now we're about to have to listen to this lion girl go over and tell us how, oh, well, they did it in the past whenever they were trafficking her, so I guess it's okay for you to do it today. Like, girl, that is embarrassing that you would be relying on that. Prior sealing orders in this conservatorship prove the existence of overriding compelling interest. No, they don't. They prove the existence of corruption. They don't prove the existence of override. No, they do not, Miss Ma'am. Appointing Jamie as conservator of the person. An order. Okay, so there's this 2009 order they give as an example that appoints Jamie as conservator of the person. Attached to Exhibit A is a very specific provision regarding the protection of HIPAA related information. And again, just freaking Geraldine, Vivian Lee, Thurene, Jonathan Park would have been the ones to draft this stuff, and they are complicit in a human trafficking scheme. So what I'm a little concerned about is that you're relying on these busted ass lawyers' analysis of anything, at knowing that they're criminals, alleged criminals, alleged by Britney, alleged. Okay, now they're gonna go over this thing that they said in the past thing. Anything with medical records is filed under seal. All pleadings containing confidential info taken from medical records or other confidential medical information that falls within HIPAA shall be filed under seal. Or look. But shall be public. Look, let's do this because I already told y'all. Shall be publicly filed in a redacted form if feasible to do so. That means you take a Sharpie. Sometimes you can do it on Adobe these days. Cross out the private stuff and return and publish the document for the public, because that is you are violating our constitutional right. Aw, thank you, Rosa. I would love to be a consultant for the Touch of Rose project. I don't know if I want to work as a lawyer though, because then I won't be on their case, because then I won't be able to do stuff like this. And I like it. I think that my place is to really explain to other folks what's really going on. Okay, so look, the part that I highlighted says it's supposed to be publicly filed in a redacted form. Take your Sharpie, cross it out, and file it with the court, Lorianne. I don't know what you're trying to hide, girl, but that's not going to work with us. It's just not going to work. The courtroom shall be closed whenever there is any discussion or argument concerning confidential information taken from medical records. And again, I don't know what they filed in 2009, if this was legal, if this was acceptable, if this was above the table. They filed everything. They also filed a thing where they lied and said Britney Spears had dementia when she was 26. Never got a doctor to approve or confirm that. So I don't know what they filed in 2009. And I definitely don't think we need to just be relying on it just because it was filed in this case, if you know what I mean. Okay. Similarly, this court granted Jamie's motion to seal proceedings in this matter on September 18th, 2019. The hearing was sealed due to the consideration of sensitive information about Britney's children, business interests, finances, and medical condition. No, ma'am. Business interests and finances is not something that's supposed to be sealed from the public. I don't know why you put that in there. We are supposed to know what the Court of California is doing with people's businesses, vulnerable people's businesses, to make sure that there is no corruption or fiduciary violations going on. Okay. Okay. Oh, woman freed. Oh my God, you are so nice. Thank you. Oh, your exposure of this corruption is invaluable to us all. That is true. Thank you so much. That is so generous. And y'all, this is the thing. when you feel in your gut, in your heart, in your soul that somebody's trying to get one over on you, a lot of times it's true, but they depend on us not knowing our rights. And that is one of my main reasons for being on this channel and telling y'all this stuff, because like I could read this by myself and just know the information. I don't have to read it. I read it to y'all because I know that it's so important that you know your rights, because every one person that knows their rights can stand up for 10,000 other people, right? It just goes on and on and on. And if we don't protect our democracy, we are going to lose it. And not only that, we're going to go extinct as a species. Like, we have to start protecting each other. All right, I'll get off my soapbox. All right, the termination plan necessarily includes, but she doesn't say consists entirely of, right? Like, look at these words. Necessarily includes information derived from Britney's medical data, reports, and conversations with her medical professionals, including their recommendations for post-termination medical and other services, as well as medical and other private information that impacts her relationship with her minor children. Okay, look, I highlighted this word includes because it's very important. Even Lorianne can't lie and say the whole entire document is nothing but, and then the medical data, reports, conversation, blah, 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 right? She says it includes it. So girl, what was your rule you just quoted? Publicly filed in a redacted form if feasible to do so. So do that. What's the holdup? Y'all just don't want nothing in this case to be public. Nothing. Again, if you're just joining us, this is the same woman who tried to seal the hearing on June 23rd where Britney actually finally did speak. Britney finally came out and said, I've been abused. My family should go to jail. I've been, she compared her situation to trafficking. She came out and spoke that day. She said, I don't want this to be a hush-hush secret. I want it out in the public. I want to do a public interview. I want to just tell everybody everything. The same lawyer that day said, oh, let's keep the courtroom closed. Maybe Britney's going to talk about something about her children. Britney said, no. You have done a good enough job exploiting my life and I want it open. So I'm just confused as to why all of a sudden Jodi and Lorianne Wright are even involved in this termination plan. This is not something I'm going to stand by and watch idly by. She's saying all this information constitutes sensitive information. All of what information? Look, this is how you study for the LSAT. If y'all are doing that, you got to follow the thread here. It includes some information. That's not all the information. But of that information, of this little subset of info, all of it is private. Okay, then black it out with a marker and make the rest publicly available. All this word games is not going to confuse me, Lorianne. And it's not going to confuse my followers, Lorianne. But it might confuse Judge Penny because she's corrupt and wants stuff to be sealed. If she seals the whole entire thing, maybe that's the reason. I got to stop making lives at 10 in the morning because I don't know why. I just wake up like ready to go. By the afternoon, I'm a little more subdued. Okay. Number 3, the termination plan must be sealed in its entirety. No, it must not. I just don't disagree with you right there. Y'all know I make stuff pink when I disagree with it. So false. I'm just going to disagree with you. Take me to court. This court was absolutely correct in its prior decisions to seal records in this conservatorship case. Not only does the public have no right of access to conservatorship proceedings, this is false. This is false. Where's your case law to support this false proposition? Why are you lying, Lorianne? Why are lawyers lying in this case? The public absolutely has right of access to conservatorship proceedings. They are situated exactly the same as civil proceedings, which we do have public right of access to. Stop lying to people, Lorianne. Just because you lie, this is perjury or malpractice. You know good and damn well, Lorianne, that the public has rights of access to conservatorship proceedings. This is a false statement and you're lying. What else have you lied about what else have you perjured yourself for in these documents, Lorianne? You're walking on eggshells as it is. You're on thin ice. I'm so annoyed that she would just bold-faced lie. What is she, CNN? Not only does the public have no right of access to conservatorship, anytime you see something in pink, that's a lie. According to me, in my opinion. Miss Spears' medical and other private information contained in the termination plan. Okay, this is true. This is true. Britney's medical and private information contained in information, that specific information contained in the thing is confidential by law. We don't disagree on that. What we disagree on is that the public has no right of access to conservatorship proceedings because that's a lie. And while this court is not required to consider anything other than Miss Spears' per se confidential interests, that's not true. The court is required to consider lots of things. Aw, thank you, Edward. There's also no question that those overriding interests will be prejudiced if the termination plan is not sealed. That is not true. This is just her just lying. What on earth? There is no question that her interests are prejudiced if the termination plan is not completely and entirely sealed. That is just a lie. They just be writing anything on these papers and trying to make be like, oh, hopefully this one, no one catches me in this one. Y'all are ridiculous. This is unethical and immoral. What law guarantees the public's access to these proceedings? The United States Constitution. There's also no less restrictive means. Okay. For all these reasons, the termination plan must be sealed in its entirety. I disagree. And you know what? Matthew Rosengart, I hope you come in. Look, there's no constitutional right of access to conservatorship proceedings. This is not true. There absolutely is. There's no difference between a conservatorship proceeding and a civil proceeding as far as the public's right of access. There is and People versus Dixon is actually what says that. So they're using they're using the case law to support the opposite proposition of the truth. Oh, Christina Lowe. That's interesting. That is an interesting question. I do think they do, though, Christina. Thank you so much. I do think that in California, I do think that they all do have a law degree because I've looked all these lawyers up and seen where they went to law school. Steve says Jodi is part of the corruption. She is trying to hide her role in this. Justice must be served to anyone and everyone involved in setting up the conservatorship and benefiting from it, and they must be jailed. I agree. Surprise witness, all one word. Thank you, Monka. I hope Matthew spits on this document too, but at the end of the day, like, Britney might just not even argue this. She might not care. It might not be like the hill to die on. Do you know what I mean? While there's unprecedented interest in any document filed in this case, well, at least she acknowledged that. There's no absolute, let's technically right of access to conservatorship proceedings. Yeah, well, there's a pretty fundamental right, though. The United States Supreme Court has set forth two related considerations for public access to court proceedings. First, whether the place and process historically, thank you, Kay, whether the place and process historically have been open to the public, and second, whether the public access plays a significant positive role in the particular process. Well, we go ahead and bust that one right out the water then, don't we, Lorianne? Because if it weren't for the public's access to this case, Britney Spears will probably be literally dead or definitely still in a conservatorship. So I would say we pass this test, you fail this test, and you're an embarrassment for including this as precedent, as something you're relying upon. I'm sick and tired of you lawyers trying to act like you, because you can do your little words and dance around case law, that somehow common sense doesn't prevail. Lorianne Wright, when you're sitting and having your hot chocolate by your fireplace tonight, free and in control of your own money, I want you to ask yourself, if you really think that Britney would be free if not for the significant positive role that the public access has played in this particular case. Okay? I really want you to ask yourself that, because there is absolutely no way that a reasonable person could come out on any other answer other than yes. Wow. I'm just so fired up. Ugh. Okay. Now they're about to use completely irrelevant case law. Completely irrelevant case law. They're talking about LPS proceedings. This is not an LPS proceeding. This is a probate conservatorship that actually is much more restrictive and takes away completely and totally Britney's rights. That is irrelevant case law. This is not an LPS conservatorship. But here you have Jodi Montgomery's lawyer, Lorianne Wright, trying to hide all of the access that we the people, are constitutionally entitled to. Here you have Lorianne Wright in bad faith using an LPS statute. You know why Britney's not in an LPS conservatorship? Because they were able to say, that she had dementia and take away all her rights, not just some of her rights. So now what's good for the goose got to be good for the gander, Lorianne. If y'all wanted to use LPS case law, you should have put Britney in a LPS conservatorship, but you didn't. You put her in a probate conservatorship. And so now you're trying to use all this irrelevant case law that has nothing to do with the price of beans in China, but you trying to put it in this thing like, oh, look what they do over here in LPS cases. Well, you know what else they do in LPS cases? Let people keep their money. But y'all didn't do that, did you? Sure didn't. It's ridiculous. Why are you using LPS case law? Don't have shit to do with this proceeding, and you know it. And you know it. This has already been argued about in this case. They've already used these LPS cases, and Matt, or maybe it was Sam Ingham, have already come back and said, yeah, but that's an LPS case. That doesn't have anything to do with this probate conservatorship. That's like saying, oh yeah, here's the case law that applies to criminal courts, but you trying to use it in the civil case. It's like, it doesn't always necessarily translate. So why don't you find us some probate law that says that, Lorianne? The reasoning in the Dixon court is directly applicable here. This conservatorship proceeding, like an LPS proceeding, no, wrong, wrong. The reason that LPS proceedings exist is because the same statutes are not supposed to apply to them. Wrong. You're wrong, Lorianne. And you look dumb. Thank you, Mimi. Thank you. Far, far away. Oh, love your unicorn. Not common law, the termination plan involves a primary personal and confidential matters, such as, she's just reaching at straws. Grasping at straws. Since, they think if they just keep throwing around the word sensitive private health information, that all of a sudden the public's going to be like, oh, okay. No, you cross that part out and you put the rest of it up for everybody to see. That's the point. We don't know what y'all are about to do with this thing. Furthermore, granting public access to this document would seriously undermine the goal of the conservatorship by discouraging medical and other professionals involved to care and provide services. What? This is pretty crazy, y'all. Look at them admitting to their crimes right out in the open. I didn't mean to make that green. Hold on. Look at them. Look at these criminals. If the public had access to this document, it would seriously undermine the goal of the conservatorship, which I think needs to be undermined because the goal of the conservatorship was to control Britney's body and money. Okay. By discouraging medical and other professionals involved in Britney's care to provide their services or give honest recommendations as to her. Are you telling me right now, Lorianne, that doctors refuse to actually get involved with y'all unless their dealings are completely private from the public? Listen, do I have any doctors on here? Comment in the comment section below if you're a doctor or a medical professional and you would not want to be in this case because maybe what you're doing would be public. Because that seems a little bit shady to me. All the lawyers, what they're doing in this case are public. This is strange. It would discourage medical professionals to provide their services. Don't they take a duty and an oath to make sure that they don't do any harm? Wouldn't it be pretty harmful for them to care more about their ego and their reputation than continue the care that they promised to give to Britney? I don't know. Listen, I'm not a doctor. Somebody tell me. But this is a really weird thing to admit to out in the open. Listen, Judge Penny, if you don't let us keep all of our dealings secret, all of a sudden these doctors that we specifically handpicked are not going to want to do it anymore. Well, maybe they don't need to be the doctors doing it. Perhaps. If they're so scared of the public having our constitutional right to knowing what's going on. I mean, it's weird. Who's Dr. Mike? Sorry, I don't know who Dr. Mike is, but if I got Dr. Mike on here, whoever he is, tell him come over here and we talk about this LPS and this medical HIPAA and all that. Notwithstanding the extraordinary interest in these proceedings, look how she just throws it right away, right? She's acknowledging there's extraordinary interest in these proceedings. And then she's like, nah, but forget about that. That's what notwithstanding means, right? Like notwithstanding this very important thing, right? Notwithstanding all of your constitutional rights, the public has no right of access to the termination plan. False. False. You are lying. That is not true. Which necessarily contains sensitive private information. Now, we are not entitled to that private information. Again, all of this part we're not entitled to, but never in this paper one time ever, never in this filing so far has she said, and the whole document is medical information and personal private information. She said it contains personal and private information. That personal and private information should be redacted and we should see the rest of the termination plan. We do have the right. So all this in pink means it's lies. Okay. As discussed below, California's constitution and rules require that it be sealed in its entirety. Lies. You're false again. Nope. Medical information is confidential by law. Okay, this is true. We don't really have to go through all this because I agree with this. Medical information like a diagnosis, prescriptions, hospitalizations, et cetera, are confidential by law and they are not supposed to be open to the public. I agree with that. So that part of the termination plan should be sealed. It should be done away with, redacted, right? That part of the termination plan. Somebody needs to take a big black Sharpie chisel tip and over all that personal information that's private and medical. So we don't really need to read through that. Medical records are presumptively private. I agree. That is true. You are for once not lying. Okay. Again, we see this word includes. She doesn't say consists entirely of. And I know that seems nitpicky, but listen to me, y'all. That is listen, what page are we on right here? We're on 6. Up here, they agreed to this in this very case. All pleadings containing confidential information taken from medical records or other confidential medical information that falls within HIPAA shall be filed under seal and shall be, look at the highlighted part, publicly filed in a redacted form if feasible to do so. So what Lorianne should be arguing in here is it's infeasible to file this in a redacted form. That is what she should be arguing. But instead, she's trying to make it seem like because there is some information that's private, that the entire document needs to be sealed, which is not the law. B, not constitutional, and C, perhaps most importantly, not what the people in this very case agreed to. Like this, sorry, that made y'all dizzy. This is what they agreed to. Publicly filed, they all agreed to this. So I don't know why all of a sudden now, Lorianne has some type of comprehension problem. The termination plan includes, relates to, and is derived from Britney Spears' confidential medical information. So it should be filed in a redacted form, like you all agreed. Okay. The fact that Miss Spears is a conservatee, well, she is no longer a conservatee, but she was at the time of this filing, and a celebrity. And there has been an unbounded and relentless curiosity in all she does. Yeah, including by the people who were her handlers and traffickers, including your client, right? Unbounded and relentless curiosity in all she does has no impact on whether it should be disclosed. Again, what's good for the goose has to be good for the gander, Lorianne. Whenever this conservatorship was started, a big reason why they took away her constitutional right of notice and due process under the law was precisely because she was a celebrity. So now, because she's a celebrity, all these people are interested. It's not working for what you want, which is to keep all of these crimes hidden. It's not working for what the conservator team Con wants. Now, all of a sudden, just because Britney's a celebrity don't mean nothing. Well, in 2008, it meant a whole lot because it was one of the reasons y'all violated her constitutional rights. Team Con, LA Probate Court at Stanley Moss Courthouse. The court cannot serve as a conduit through which confidential information is transmitted through other members of the public. Sure, but the court can also not take away our constitutional right to see the rest of the information that is not private and medical. It is indisputable that the termination plan, which contains health and medical information, is precisely the type of record which is required by law in numerous contexts to be confidential. No, false. False. Again, contains, baby. You're not saying consists entirely of. Highly sensitive personal information is confidential by law. Dissemination of the termination plan to the public at large would further violate the privacy rights of Miss Spears. No, it would not. No, it would not. No, it would not. Britney Spears said, I don't want this to be a hush-hush secret. Y'all have exploited my life. You've kept this hidden away in the dark. I want to tell everything. I want it all to be public. And here you are, oh, privacy rights. Oh, dear, privacy rights. Oh, Britney's privacy rights. Okay, well, what about her privacy rights when y'all didn't let her have a door to her bedroom? Or when you were taking vials and vials of blood from her body that she didn't consent to? How about her privacy rights whenever you, Lorianne, you, Jodi Montgomery, got to just open up her medical records and just look through them? She didn't choose or consent to y'all doing that. Y'all didn't care about her privacy rights then. But whenever her privacy rights are perhaps coming into play where people are going to see what you did, what you were complicit in, all of a sudden now you care about Britney's privacy rights. It's so transparent, it's so corrupt, and it's ridiculous. Ridiculous. It's appropriate to seal certain records when those particular records contain highly sensitive personal information about individuals. Yeah, but what about Britney's desires? Are we going to talk about that? Britney has full expectation and constitutional right to privacy. Well, why didn't Britney file this? Don't y'all think it's funny that Lorianne Wright is filing this petition to seal a record, but Matt Rosengart didn't? And Britney Spears didn't? I think it's kind of funny and interesting. Britney has full expectation of and constitutional right to privacy, but her lawyer, y'all, this is not Jodi Montgomery's lawyer's job to assert Britney's privacy rights. It's Matthew Rosengart's job to do that. So why didn't Matthew Rosengart file this petition? I'm concerned. I need to change the thumbnail. What is Jodi Montgomery hiding? What is she trying to hide? While the termination plan contains the most obvious class of confidential information, medical information, it also contains other information that would lead to embarrassment or indignity, including information with respect to her minor children, which is protected under Family Code 1818. Sealing is the only way to protect the sensitive and private information revealed in the termination plan from being widely disseminated and picked apart in a public. There it is. This is what they're scared of. Me and you. And us. We don't want what we do picked apart in a public forum. That's what it is. Don't got shit to do with Miss Spears' detriment. Let me make this pink. This has nothing to do to Miss Spears' detriment. Not one thing. Us picking apart this case and what these lawyers have doing have actually helped. Has actually saved Britney from a conservatorship. And to hear her tell it as recently as yesterday on her own Instagram saved her life. Knowing what's going on in this case and getting the news out to the public is what saved Britney's life, according to her. And now Jodi Montgomery's lawyer is saying, oh, the public doing their constitutional right and holding us accountable would hurt Britney. That is not common sense at all, is it? How much more embarrassment can Britney actually possibly have? She just told us yesterday, I've never seen cash, and I realize how embarrassing it is for me to say that. But what am I going to do? I was in a conservatorship. I think Britney might have been commenting a little bit low-key on this document in some of her posts yesterday on Instagram. Slight detour. People are asking if my 3 videos have been put back up yet. Evelyn. The videos have been put back up, but I still do have a copyright strike on my channel. I will not be going to copyright school because I am a lawyer and I already paid $250,000 to go to school to learn about the law. So I'm not doing that just on principle. So they're going to have to remove the copyright strike or we're going to be going to court. All right. It's a good question. So confused. I'm also so confused. Why would Britney want Jodi in her life? Who are the birdies that Britney referenced? That's a great question. Okay, let me get back to this and we can talk about that then. Okay. Since the termination plan contains highly sensitive personal information about Britney Spears, it is appropriate to seal those records in order to protect her and her children's right to privacy. Again, Jodi Montgomery's lawyer is not the appropriate person to be pleading about Britney's privacy rights. That is her lawyer's job. And now they're going to say, okay, all right, fine. Even if the public has a right to this, right? Remember how Lorianne Wright just spent the last 3 pages talking about how public doesn't have the right? Look at this title. She spent the last 3 pages talking about we don't have the right. We don't have a constitutional right. Making LPS comparisons don't have shit to do with this case. Now she's saying, oh, okay, just kidding. They do have public access arguments, but we still should be able to seal this record. Well, girl, you should have just started here because you just lied for the last 3 pages, making yourself look stupid like you didn't even go to law school. Aw, thank you, Kylie. Thank you, Wild Woman. As stated in section C and B above, where I was lying through my friggin' teeth, the information contained in the termination plan is per se confidential, even assuming that the public has right of access to conservatorship proceedings, which we do. Even assuming, for the sake of argument, that's what arguendo means, for the sake of argument. Okay, baby, well, it's not for the sake of argument. It's for the sake of truth. I don't know why I keep making it green. I hate green. I don't hate green, but I hate green as a highlight color. Miss Spears held them okay, which it does not. False. You're wrong about that, Lorianne. But listen, y'all, I can't really put it past her because she's a conservatorship lawyer. If there were no conservators who take away people's rights and enslave them, then there would not be a job for Lorianne. She represents conservators. She represents slave owners. She represents these people. So she has to be the bad guy. And this is what happens whenever you go into the legal profession and you don't know who you really are inside. I was able to get out. I was able to say, this is not who I am. This is immoral. But Lorianne Wright doesn't seem to have ever actually had to face that consequence, hasn't ever had to face who she is as a person. So she's out here just representing slave owners. I mean, literally. Again, and she's trying to, like, every lawyer, whenever we swear in, no matter what state it is in the United States, we have to put our hand on something important to us. Let me show you what I did. I'm not real religious, so I use this Legally Blonde VHS from Blockbuster Video. And I put my hand on it and I said, I promise I take an oath to uphold the Constitution of the United States. And I'm telling y'all one thing, I take that oath very seriously. Does Lorianne Wright? Because it seems like she doesn't even know. Seems like she doesn't even know what the Constitution even says. So I don't know how she's going to uphold it. How's she going to uphold it? She doesn't have the right. We have the right to this. We have the right to the conservatorship proceeding. If we didn't have the right of access to a conservatorship proceeding, the courtroom would be completely closed. They would not let us in to any conservatorship proceeding. Y'all understand that? Everyone should have to swear in on a Legally Blonde VHS from 2002. I agree. The court's decision whether I bought it on eBay, y'all. I didn't like keep it from Blockbuster, just so you know. I would owe like $20 million at that point. Dude, are Blockbusters still open? This court's decision whether to seal is further subject to the standards and procedures set forth in Rule of Court 22.550. Following those standards, this court may order that a record be filed under seal if there is substantial probability that exists that the overriding interest will be prejudiced if the court record is not sealed. The proposed sealing is narrowly tailored. Again, narrowly tailored, Lorianne, you know it and I know it, means redacted. And no less restrictive means, no less restrictive means, again, we know that means redaction, Lorianne. You know it and I know it. I'm not letting you get away with this. Sorry. She's citing this rule that basically says, okay, even if the public does have access to something, even if they have a constitutional right, there are some times where it's still just so important to keep the information private that it will outweigh the public's constitutional right. But in those cases, you have to prove a few things, and the burden of proof is on Jodi. She has to prove that the proposed sealing is narrowly tailored. Tailor, like you tailor a garment, right? Like very, very, like it's tailored very narrowly so that we still have access to the information we should have access to. And we're not just over broadly limiting access to everything, right? So what's going on here is usually, and courts have found in the past, redaction is a way to narrowly tailor. Now, let's go to the next part of this. No less restrictive means exist. Well, there is a less restrictive means than sealing the whole document, and that's redaction. It's crossing out the pages or the areas that are private, and it's letting the public have access to what we are constitutionally able to access. That literally is only going so far as to cross it out with a marker. It's not like, oh God, we're asking you to do so much. What are y'all trying to hide? first, given the unprecedented media attention given to this matter, well, maybe that's y'all's goddamn fault. Y'all spent $500,000 on media matters. So maybe perhaps the reason there's so much media attention is because y'all been paying the media. Y'all been paying the media $500,000. Who knows how much it's up to now? Britney's overriding medical and other privacy interests will unquestionably be prejudiced. No, I'm questioning it, so it's not unquestionable. Wrong again. I'm questioning whether or not her interests are going to be prejudiced. I don't think they will, so I just questioned it. So I guess it's not unquestionable, Lorianne. It is virtually certain. What does this even mean? What does virtually certain mean? What in the hell? It is virtually certain. So you mean it could happen? It's possible. That's what you meant to say? It's possible. What's virtually certain? Certain, it has a meaning, lady. So she means it's possible that in the absence of a sealing order, the confidential information would be circulated on all social media platforms, and it would. And that is our right. That is called the freedom of the press, and it's a First Amendment right that we all have. You do not need a press pass. You do not need a press badge. You do not need a press job. We have the right to disseminate and circulate information that is our constitutional right. It's called the freedom of the press. When you took the oath to uphold the Constitution, you took an oath to uphold the freedom of the press. And now you're arguing against it. You look dumb. And you look like a promise breaker. You have to uphold the Constitution of the United States, Lorianne. You know that freedom of the press includes social media. Don't matter if I'm putting it in the New York Times, the New York Post, YouTube, Rumble, Telegram. Don't matter. I don't care that it makes you uncomfortable that your dirty deeds are going to come out. That's not the constitutional standard, baby. The constitutional standard is we have the right, oh God, the cat's here, to circulate all of the information we have the right to see on social media. Oh no, Your Honor, they're going to put it on social media. Yeah, we are. It's like the whole point. That's why Britney's free today. If not for social media, Britney would be in a conservatorship and you people would still be draining her for all she is worth. Let me let this cat in. Aggravating. Come on. Why do you always do that? It's annoying. Sorry, the cat gets like worked up. Yeah, if people are hating, just like delete them from the chat. Thank you, mods. Just like delete them from the chat, like mute them. Okay. Okay, so here she is being scared. We're going to put it on the social media and be included in future unauthorized documentaries about Miss Spears. Who gives a shit? That is not a constitutional standard. People are going to be making documentaries about Britney Spears. And I understand that she doesn't necessarily like it when it's not authorized and stuff like that. That's fair. That's her right. But to be honest, I got to be fair here. It is people's constitutional right, freedom of the press, to make documentaries about anything and anyone they want. It's a right. It's called the freedom of the press. If you don't like it, take it up with the United States Constitution, make an amendment. That's what it says. Those disclosures are certain to cause Miss Spears embarrassment and emotional harm as they would be publicized across the world. Again, if Britney Spears said this, I would be more sympathetic. But Britney Spears did not file this. Her lawyer is the one who is supposed to be filing sealing orders and all that stuff. Like, this has nothing to do with Jodi Montgomery. Britney's privacy interests would undoubtedly be compromised by being open to public view, and Miss Spears' unquestioned right to maintain the confidential. Okay. This is right. She has a right to keep confidential her medical information, but that is why it's supposed to just be redacted. It's not supposed to be just the whole thing is sealed. Second, the proposed sealing is as narrowly tailored as possible, which it is not. You were supposed to redact. And no, stop meowing. Come here. Come here. Come here. The public's interest in the access has already been satisfied because the public has had access to the numerous other pleadings filed with the court. False. That is not the standard, and you know it. And if you don't know it, you should lose your freaking license because this is such an idiotic thing to think. The public's interest has already been satisfied because they had access to other documents? What on God's green earth? The public access, imagine we're in the Kyle Rittenhouse case, right? Let's just imagine it. And they only had just the first complaint filed, and none of the other exhibits, none of the other responses, none of that was open to the public. Only the very first document in the case was open. Would that satisfy the public's right to access? Or would it be kind of weird that we can't see everything going on in the case? Same here. It doesn't satisfy the public's right of access because y'all already had the few documents you weren't able to seal and hide away from us. That's false. How these lawyers just lie in these documents continues to blow my mind. I know it doesn't blow some of y'all's minds, but like, I'm not going to get into it, but like, I was watching the Kyle Rittenhouse case. I won't say if it was the defense or the prosecution, but one of them just kept lying. And I was like, this person is lying. They're standing up and lying. Like, what? This is a lie. The public's interest has already been satisfied because the public has access to other documents. That's false. That's just false. Why are you lying? Information has already been publicly filed that discloses all but the most confidential information regarding Ms. Spears' finances, career, personal information, and other information. So that don't have nothing to do with my rights. Nothing to do with the public's rights. We, the people, have a right to know what you corrupt people are doing to Britney Spears, her body, her money. We have a right. I don't care that you had a couple of open documents before. That doesn't have nothing to do with me. The termination plan is personal to Ms. Spears and has no value to the public. False. This woman is breaking her promise to uphold the Constitution of the United States of America. And you know what, Lorianne? It's despicable. It's disgusting. I am disgusted at you. Disgusted. I could throw up. I could vomit. That's how disgusting you are. There's no value to the public other than to satisfy the base curiosity. That is not keeping your promise to uphold the Constitution. You promised. You probably put your hand on a Bible and promised. You probably actually believe in the Lord and you promised. And now you're breaking your promise to God and the world and everybody by trying to say, oh, the only reason they want to see it is curiosity. No, bitch. The reason we want to see it is we have a constitutional right to see it. Stop lying. Stop lying, liar. Could be used by third parties to Ms. Spears' great disadvantage. Okay, well, it could be used by third parties to your great disadvantage, but you're also leaving that part out. It's especially so since Britney is on the brink of ending her conservatorship. This was a few days ago. And maybe the last time the court will have to protect her private information. Here it is. This might be the last time this court has to protect her private information. Wink, wink, nod, nod, court. Wink, wink. Remember, court? Hey, court. Remember when you were complicit in this? Protect the private information. That's what I think this line is. Saida, I'm always shocked that lawyers lie because I just went to law school. And when I was there, they made it seem like you could lose your license for anything. They made it seem like if you even so much as accidentally put something wrong, you could lose your license. You could get Rule 11 sanctions. You could be sanctioned. You could be having a hearing. You could be having all this. So it made me think people were actually scared to lie. Also, I'm not a liar. So to me, it is shocking that human beings can write out in public lies. I'm just so sorry if that don't shock y'all, but it shocks me because I'm a virtuous person. I have virtues and morals. Things like integrity, honesty, truthfulness, justice, goodness in my heart. And so the first thing I think to do is usually to tell the truth. I never think to lie. And so it is shocking to me that people can lie like this. Like, I'm all for playing technically, like, that's fun. I like that. That's intellectually fun, interesting, and I think it advances a democracy and advances a society. But bold-faced ass lying whenever you know stuff is well settled is shocking to me because they made it seem like that was some kind of bad thing in the legal profession you cannot do. And I'm realizing they do it. Judges lie, lawyers lie, paralegals lie, law students lie. They just lie. And they lie in big cases like this. They lied and said Britney had dementia. It's shocking to me because I'm scared of what can happen to me when I lie. And I thought people would be scared of what could happen to them when they lie. But I guess not whenever you have the whole full force of the government and the media and everybody else behind you. Would you get down? No. Stop. Okay. This court, having protected her private information for 13 years, would not be an optimum time for this court to start revealing it. Okay, what on earth does that have to do with my constitutional right? Nothing. Just filler. In summary, Ms. Spears' right to privacy vastly outweighs the right to the public access of the deeply personal termination plan. There is simply no public right that outweighs it. Hold on. Yes, there is. It's called a constitutional right to freedom of the press. The only conclusion under constitutional, statutory, and case authority is that Britney's private medical information, as well as recommendation derived from that sensitive information, are presumably confidential and must be sealed. Right. That information must be sealed. But there's other stuff in the termination plan that you never addressed why it should be sealed. So I'm going to say I don't agree. Service of the termination plan must be limited. Now, this is where she's going to start talking about why it should only go to Matt Rosengart and it shouldn't go to anybody else. The termination plan is akin to a care plan. It contains planning with regard to Ms. Spears' ongoing needs and best interests, just those outside of conservatorship. Do y'all want to know something real interesting? Whenever they were trying to put Bessemer Trust and John Zabel in as the co-conservator of the estate, stop it. Stop. When they were trying to put John Zabel and all these other people as co-conservator of the estate, they were saying those people got full access to Britney's medical records. And now with this termination plan, they're saying she should only person should have access to it is Matt Rosengart. Like, why was this information not private anytime before right now? Now, all of a sudden, you don't want people to have access to her medical information. But y'all have been serving this on the Geralds and Geraldines and everybody else, conservators and Andrew Weil, everybody else has had access to this information. And now, all of a sudden, you want it to be secret. That's weird to me. I agree. Who said that, Emily? I don't feel so confident about this win. I feel like these snakes are going to scheme up a way to stay latched on. And here is the documents to prove it. And you know what? We're not going to actually be able to know. Because they're going to keep it secret from us because Brenda Penny is in cahoots. She sealed everything else. It is anticipated that the termination plan will be the last care plan reviewed by the court in this case. But honestly, who are these doctors? The doctors don't want us to know who they are. Want to know why? Then we're going to look them up. We're going to see who else they've been doctors for. We're going to see what else they've been accused of. I'm very concerned. Brittany, if you are watching this, I am concerned. I would very strongly recommend, and this is not legal advice, Brittany, but if you are watching this or you ever have occasion to watch it, you do not need to take the doctor recommendation from any of these Jodis and any of these people. You can choose your own freaking doctor. I am concerned that this is another Dr. Gold, Dr. Benson situation. I am concerned, Brittany, that this is another situation like that. I would not just take anything Jodi says for face value. She is on Team Con and has worked with them. She was text messaging with your dad right after you spoke on June 23rd. She was text messaging with him about you maybe having a 5150 and locking you up again. I do not feel comfortable or confident. And if we're not going to be able to read into these people, I don't know who they are. There's no requirement that it be served on any other party. Montgomery intends to strictly comply with those rules. And they already told us, this is the scary part. They told us, I can't find it now. They told us the reason they want it sealed is because the doctors aren't going to want to work on Britney's case. Well, if you're scared to be known as working on Britney's case, is it because you're going to do something corrupt? Is it because you're going to do something illegal? I'm confused. Why people, wouldn't that be like a highlight of a career? Like, I'm Britney Spears' doctor, put it in the public filings. Like, Why is it supposed to be some type of a secret? Is it because they're connected to Lou Taylor? Is it because these doctors are connected to Sam Ingham? Y'all know Sam Ingham has a family member that works in behavioral health, like marriage counseling at one of those shady little counseling centers that does like anesthesia assisted detox. Like, I don't know who these people are. And we should be able to know, because otherwise they're going to be able to continue trafficking and abusing Britney Spears. Limited service of a personal document does not just comply with the rules. It also reflects the wishes of Miss Spears herself. I haven't seen her say that. From the history of this case, it's no secret that Britney has had contentious relationship with her family, especially her father, Jamie. Sorry, I was reading the footnote. During the September 2019 hearing, this court revoked all prior HIPAA waivers. Why? Oh, that's a big one. So there were HIPAA waivers previously, and then September 2019, whenever Judge Brenda Penny realized she was about to get busted for keeping Britney in a trafficking situation, she went ahead and revoked those waivers, so HIPAA came back into place. Cut off all the parties' access to her medical information. No, not all the parties, because whenever John Zabel came on, he got to see it. When Matt Rosengart came on, he got to see it, and that was after 2019. Sam Ingham, Miss Spears' court-appointed counsel at the time, stated that Britney would decide who would have access to her medical information on a case-by-case basis. During the hearing, Mr. Ingham also reported that Britney was extremely distressed regarding the media reports about her. Yeah, you know why she was distressed about the media reports about her? Because freaking Larry Rudolph, I have a video coming out on this, it's almost done being edited. Larry Rudolph was going to TMZ and everywhere else saying, oh, Britney's medicine stopped working. They were lying. So I would be distressed if the media was lying about me too. Britney is not concerned about the truth getting out, baby. She is concerned about your lies. $500,000 on Media Matters, liars. She adamantly opposed the release of the investigator's report to anyone. Again, who cares? Who cares? We're not asking for the investigator's report. We're asking for the termination plan and the parts that are not sealed because they're not private. Ingham went on to say Miss Spears relied on confidentiality with the court investigator and would have stopped talking to him if she knew the investigator's report would be used or seen by her parents. Again, nobody's asking for the investigator report. Instead, upon request, this court ordered all medical information go directly to Miss Montgomery as her temporary conservator of the person and Mr. Ingham. Given the history of this case, it is clear that Britney does not want her medical or other privacy rights invaded. Given the history of this case, but not given Britney's own sworn word, why didn't she file this? Why didn't y'all get her to just sign on? If Britney agreed with this, don't you think Britney would have just went ahead and signed? Yeah, I agree. Don't you think? Don't you think Britney Spears would have just said, hey, look, fans, Free Britney movement, don't worry about it. I signed this. She didn't sign this to my knowledge. Maybe she did. Given the history of this case, it is clear. Well, but not given Britney, like all they would have to do is say, look, we even had Britney agree to it. They're saying, oh, the history of this case. Well, y'all have been trafficking someone through the history of this case. So I'm not going to rely on the history of this case. The thing is, this part I don't really care about. Like, they're just talking about who they're going to deliver this to. Like, they only want to deliver it to Matt Rosengart. Like, that's fine. But I'm just like her arguments and the arguments upon which she relies is just, I don't know, erroneous in my opinion. In sum, limited service of this petition is explicitly authorized by statute and local rules. I don't know if you really proved your point there, but I agree, like, from a moral and a legal, like, from a moral and ethical standpoint, like, maybe the unredacted one shouldn't go to her mom and dad. If she doesn't want it to go to them, she should have the right to say that, but she didn't say that. Jodi said that. So that's my concern here. Due to the sensitive information contained in the termination plan, Ms. Spears' desire to keep that type of information confidential from other parties in this case. I just got the strongest craving for banana bread. These reasons, Ms. Montgomery requests the service requirement for the termination plan be met through service. Okay, whatever. Okay, so this whole section, just to recap for y'all. Recap. I was on tour in 2018. No, I'm just kidding. This whole section right here is just like, it should only, the unredacted one should only be sent to Matt Rosengart, and I think that's true. Okay, conclusion. Jodi Montgomery respectfully and unconstitutionally requests that the court issue an order allowing the termination plan to be filed under seal on the grounds that it is derived from and reveals constitutionally, statutorily, and otherwise protected medical information and personal information, blah, blah, blah. She leaves out that it's not the most restrictive means, and it is not the most narrowly tailored, the least restrictive means, and it's not the most narrowly tailored. She just doesn't even point to that, even though that's a requirement. Ms. Montgomery submits that there is no right of public access to this information, which Jodi Montgomery is not a lawyer, so clearly she's not the one who understands the Constitution. Clearly, there is absolutely a right of public access. Where's Christopher C. Melcher? I need him to come on my channel immediately and talk about this. I am so infuriated. Y'all tag Christopher C. Melcher. Tell him about this. I want him to see it, and I want to know his thoughts on this, because I'm under the impression that he even said the public definitely has right of access to these hearings. So this, Jodi Montgomery with her non-legal degree says that the public doesn't have a right to the access of this information that they have a constitutional right to. That is ridiculous. Stop. Sit down. Okay. Instead, filing the termination plan under seal and limiting service of termination plan to only Matt Rosengart is the only appropriate way to protect Britney's privacy rights. Okay. So here goes Lorianne's declaration. She's an attorney, licensed to practice law. She is the counsel of record for Jodi. She makes a declaration in support of Jodi's motion to keep everything secret, like a hush-hush secret. She attended the September 18th hearing for use with this motion. The office recently attempted to request a copy of the transcript. Huh. Wow. So Lorianne Wright she said she attended that September 2019 hearing. And she said, I wanted a transcript so that I could use portions of that transcript in this filing. But she was actually denied being able to get the transcript because the hearing was sealed. The court reporter stated she could not provide the hearing transcript unless there was a court order authorizing her to do so. So the court won't even give Lorianne the information. She was like, why? What is the court trying to keep from Lorianne? That's interesting. From my own memory and notes of what occurred at this hearing, which can be confirmed in the sealed transcript, the court granted Jamie's motion to seal proceedings in this matter on September 18, 2019. The hearing was sealed due to sensitive information, including but not limited to Britney's children, business interests, finances, and medical information. I really don't think business interests and finances are necessarily... Are y'all in here trying to keep stuff hidden for Lou Taylor? Is that what's going on here? The issue to be addressed in the termination plan contain confidential and private medical information similar to the medical information discussed at the September 2019 hearing. It is virtually certain that in the absence of a sealing order... What is virtually certain? Why do you keep saying that? You mean it's possible? Virtually certain? What in the hell does that even mean? It's virtually certain. It's possible is what you mean to say. Because she wants to make it seem like it is certain, but it's not certain. She doesn't know that. She's just waving these red flags for no reason, blowing dog whistles for no reason. It is virtually certain. What does that mean? It's either certain or not. It is possible that in the absence of a sealing order, the confidential information in the termination plan would be circulated on all social media platforms, which is our constitutional right as the freedom of the press, and be included in future unauthorized documentaries. So freaking what? This is not a reason to deny the public our constitutional right. Oh, there might be a documentary, so you don't get your rights. No, what on earth are you talking about? Virtually certain. This is so scary. Like, honestly, like, I thought they were just going to let it go and be like, all right, here. Like, but honestly, this is going to be an uphill battle the whole way. Britney being free was just part one. I feel like this is like a Lord of the Rings trilogy. And we just got to where we saw the tip of the mountain. Now we got to go all the way through the whole thing now. I mean, you know what I mean? Revealing Miss Spears' personal and confidential, whatever. Okay. During that September 2019 hearing, Sam Ingham asked the court to revoke all prior HIPAA waivers. I'm assuming he asked the court to revoke prior HIPAA waivers because Britney didn't want her dad and mom or whoever to see all her information anymore. Sam Ingham stated Britney would decide who would have access to her medical information on a case-by-case basis. During the hearing, Mr. Ingham also reported that Britney was extremely distressed regarding the media reports about her and adamantly opposed the release of the investigator's report. Yeah, the media reports about her were lies from Larry Rudolph. Go look at, I have a video coming out on this. Y'all see. Mr. Ingham went on to say that Ms. Spears relied on confidentiality with the court investigator. All that's fine. Seal that part. Seal those parts. You don't get to seal the whole thing because some of the information is private. That's the gist. Like if you take one thing away from this whole thing, you don't get to seal an entire document because some information in it is private. You are supposed to redact that part of the document. That is what is supposed to happen. That's the takeaway here. TLDR, that's the takeaway. Should this court need to confirm? Oh, wait. At the same hearing, the court revoked all prior authorizations and releases related to Britney's medical information and ordered that all medical information go only to Ms. Montgomery and Mr. Ingham. So Montgomery's like, okay, well, as long as I get to peer and look into Britney's medical information, then that should be fine. I don't really care about anyone else. Like, I don't know. It was weird. For the record, I do not want to see Britney's medical information. I believe it should be private by law. I believe it should be private by morals, by ethics, by virtue. I think it should be private. I do not want to see it. I don't want it leaked. I don't want any of us to know about it. But those are not the parts that we have the constitutional access to. We have constitutional right to access public hearings and public proceedings and public documents. And that means they have to redact private information and let us have our constitutional rights. Should this court need to confirm or recount the September 18, 2019 hearing via the actual transcript, then they request the court issue the needed order so she can obtain a copy of the sealed transcript. I have met and conferred with Britney's attorney, Matt Rosengart. He has confirmed that Britney does not want her medical privacy invaded by her father or any other party in the conservatorship. Okay, that's great. Again, we don't want her medical privacy invaded either. We are all in agreement. I don't know. I don't want to speak for y'all. I am in agreement. I don't want her medical privacy invaded. But I do want to know what they're planning on doing with these percentages and this money. Exhibit A. This is the original appointment of the conservator from 2009 when it was made permanent, I believe. Look, the conservatee need not attend the hearing. So look, they made the conservatorship permanent. Britney wasn't even at the hearing. Look, Jamie. Look at this. This is where Sam Ingham was entitled to receive compensation for legal services rendered of up to $10,000 a week he could bill Britney's estate. $10,000 a week. He could actually bill even more than $10,000 a week. But the issue was he was at least guaranteed to be able to bill up to that much if he wanted to. Orders as specified in attachment 29. Okay, let's do this. This is the powers that the court actually gave Jamie Spears. So look at this. I always like to go back over these. A lot of people are new here. This is the powers the court gave Jamie Spears over Britney Spears for the last 13 years. The power to restrict and limit visitors by any means, except they couldn't prevent her from meeting with Sam Ingham. Arrange for appropriate security in order to protect her. Again, look, listen. Oh, she's famous. I know she's famous, but that doesn't mean that the people get to see what's going on in her case. Okay, well, the reason y'all put her in a conservatorship and put all these things in place was because she was famous. Look at number B, letter B. The conservator, Jamie, shall have the power to retain caretakers for Britney on a 24-hour, 7-day-a-week basis. The power to retain handlers, traffickers, security guards. It doesn't actually say handlers, traffickers, but that's what they were. For the conservatee. The power to prosecute restraining orders, which they did use very gratuitously. The conservator shall have the power to communicate with treating and other medical personnel regarding the conservatee. So Jamie could talk to all Britney's doctors, have access to any and all records except psychiatric records, which I don't understand. Psychiatric health is health. So why is it like he gets to see her gynecology records, but not her psychiatric records? He shouldn't have gotten to see none of that stuff. It's what's good for one is good for the other. The conservators shall have access, subject to the reasonable discretion of the primary treating physician or psychiatrist, which Jamie would have picked. Jamie, Lou Taylor, these people would have been involved in these medical decisions. They would have given her maybe an illusion of choice. Here's 2 doctors to choose from. Here's 3 doctors to choose from. But primary treating psychiatrist, the conservator shall have access, subject to the discretion of the doctor that Jamie hired, to any of all records. So Jamie hires the doctor, and then the doctor gets to be the one to decide whether or not Jamie sees, like, y'all see how like that's not really meaningful? Like, he's the one who hired the doctor. So of course the doctor's gonna have the discretion to let him see what Britney is doing, right? The court granted other orders. The court appointed a Dr. Stephen Marmer to do a 7:30 evaluation. And the Stephen Marmer is like a Alzheimer's and dementia doctor for old people. He's a geriatric doctor. He's Sam Ingham's friend. He's who Sam Ingham recommended. Britney didn't recommend him. Britney did not choose this doctor. And I don't know if he ever even did a 7:30 evaluation. Stop. All documents that would be protected under HIPAA are filed under seal. All pleadings containing confidential. This is from 2009 if you're just getting here. The courtroom shall be closed whenever there's any discussion or argument concerning confidential information taken from medical records or that falls within HIPAA. It is further ordered that to the extent that the conservator wishes to file under seal financial records, he may file a motion to seal pursuant to the procedures and standards set forth within. And then you have Andrew Wallet and Reva Gates, corrupt, dishonorable Reva Gates, who now is still deciding cases as an arbitrator, who should lose her law license and go to prison. Human trafficker. Okay, this is the proof of service. Jamie's attorney is Justin Gold, John Zabel, Geraldine Weil, Glad Jones, Lynn Swanson, Yasha Bronstein. Okay, so that's the that's what we have so far. So, I don't know. I'm annoyed. It's slow in here. They got to Michael Jackson. Luckily, he warned Britney before she walked away. Yep, Gerald and Geraldine were on Michael Jackson's case. Michael Caine, who's Britney's current business manager, was Michael Jackson's business manager for only a few weeks before he died. I'm very suspicious that they had Michael Jackson killed. His death was actually ruled a homicide. Like, it's no secret, even legally, that he was murdered. So, am I going to read the new trust filing too? Is it up? It's literally a crime. It is a crime ring. It's organized crime. We do need to talk about Michael Caine. Okay, so apparently there was like other documents filed. I'm going to go. I'm not going to stay on live all day here on this one. Like, there's a couple other things I need to do. Thank y'all for coming, hanging out. Thank y'all for supporting the channel. I'm very excited to continue reading these documents and holding these corrupt courts and lawyers accountable. I basically lost my job because of this conservatorship, so I'm definitely going to be seeing it all the way through. If you don't know what I'm talking about, go watch my exposing Lou Taylor video. I'm going to go feed my cat because she is literally screaming at me. Faxing defamation. Talk to y'all really soon. Love you, mean it. Okay, bye.